for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Are you serious?
Time to get back to Radio Law Talk on RadioLawTalk.com and on your favorite radio station.
In February, if you watch the wonderful Super Bowl, probably one of the best commercials and funniest commercials was in ancient times that shows the Bud Light people cruising around with this big, huge, barrel full of corn syrup.
Let us take it to them at once.
Listen. Put it on pause for a second. Put it on pause for a second, Cal. So what they're doing is taking, those of you who haven't seen it, who are living under a rock, taking this corn syrup around, and it was, quote, it was accidentally delivered to the old Bud Light castle, and they're taking it to Coors and Miller's castle. Say, isn't this your corn syrup? And they argue they are not. They don't have corn syrup in Bud Light. Go ahead and play the commercial.
My king, this corn syrup was just delivered.
That's not ours. We don't brew Bud Light with corn syrup.
Miller Lite uses corn syrup.
Let us take it to them at once.
It shows them going across the mountains.
If something did happen, we'd eat the wizard first, right?
Yes. Oh, yes.
Oh, brewers of Miller Lite, we received your corn syrup by mistake.
That's not our corn syrup. We received our shipment this morning.
You're joking.
Try the Coors Light Castle. They also use corn syrup.
You guys see it, this old medieval.
Can you smoke outside?
Oh, brewers of Coors Light, is this corn syrup yours?
Well, well, well. Looks like the corn syrup has come home to be brewed.
That's it. That's it. So anyway, that commercial alone has sparked lawsuits galore between Coors and Miller and Bud Light. Now, how this occurs is during the fermenting process. Apparently, Coors and Miller do use a corn syrup type base, but it's during the fermenting process. So there's no corn syrup, I'm giving the overall general picture, in the beer. It's just for the fermenting process, where apparently Bud Light doesn't do that, but still they're claiming and arguing that Bud Light's misleading the consumer in thinking that they have corn syrup in their beer, which it's not in the beer, it's just in the fermenting process. Therefore, they sued, and here's the most interesting thing about this whole thing. Guess what? So, Miller and Coors win this part of the lawsuit that we're thinking, wow, it's a huge hit on Bud Light, who says they're going to appeal, and Miller and Coors win in the court. Said it was a Wisconsin federal judge, said they have a certain amount of time to take the word no corn syrup off their packages. That's Bud Light's packages, because it insinuates the other guys, Miller and Coors, have corn syrup. Now, that alone, legal argument, I don't follow that, Your Honor. I don't follow that, because why can't Miller and Coors put "we have no corn syrup in ours too" on their labeling? But the weird thing is the judge said that insinuates your competitors have it on theirs. I'm like, what? I mean, that is the weirdest thing. And then to top it off, let me finish my final point. Yeah. To top it off, no, go ahead. Top it off. What's the big issue there? So he tells them to take it off. I'll let Denise finish.
He tells them to take it off their packaging, but he says you guys can use the rest of the labels that you've got. So he takes away that penalty, if you will, and then they leave the underlying Bud Light commercial that was played at the Super Bowl in place.
And the judge says, okay. The judge says you can keep doing that.
It's kind of a weird decision.
Now, I'm okay with that part of the ruling, because when you watch the commercials, at least in the commercials, they say not brewed with, and the fermentation process is part of the brewing process, so there's a little bit more information versus just putting no corn syrup on your package, which would, I agree with them that it tends to insinuate that others have it in there, but so does fat-free. You know, fat-free tends to when the first Diet Coke came out that was sugar-free, or the first beverage came out, if others wanted to do that, they could go ahead and put a product out there that said sugar-free. It's called competition in the marketplace. And oh my gosh, shocker, somebody would do a commercial that led others to think something about another product in the marketplace might be inferior. Oh my, say it isn't so. That's just the market, for crying out loud.
And I agree, and that's why it's like so bizarre to me to say that saying no corn syrup on your packaging is insinuating all the other competition have corn syrup. That just to me is a bizarre ruling.
I see this ruling as a ripe freedom of speech issue in advertising, saying, look, the court cannot limit their ability to say no corn syrup. Anybody else, you guys can go put it on your package too.
And see, I agree with that, because they don't brew it with corn syrup. They do have a different product.
Yeah. So you nailed it. If they're telling the truth, why is that a problem?
Right. Truth is an
What's
absolute
wrong with
defense.
the truth? Right.
Well, Miller Lite has said, or Bud Light has said that they vowed to continue to make this a case, and they are going to continue to push forward. Interestingly enough, apparently this issue actually nixed a joint marketing agreement that Miller and Anheuser-Busch had together for future commercials where they're going to kind of compete. You've seen this in other advertising, especially during the Super Bowl. There was one where the guy kept showing up in other commercials and stuff, and that kind of nixed that. But my thought is, well, if you can get your product in the public eye by filing a lawsuit, maybe you're doing it as well. We've kind of seen that happen with copyright lawsuits and with all sorts of things. There's a lot of advertising juice to filing a lawsuit, isn't there?
Go to the website, radiolawtalk.com. That's radiolawtalk.com.